Now, look at the Wildlife Protection Act of 1972. Now, it is not that we did not have the laws dealing with wildlife or regulating wildlife. We could come across some of the colonial legislations like the Wild Birds Protection Act of 1887 and Wild Birds and Animals Protection Act of 1912. Now, one could also see that these colonial legislations were enacted for certain vested reasons, may not be to suit the demands for conservation of those resources or for protection of environment for that matter. But in 1972, post independence India had enacted the Wildlife Protection Act by making use of the provision under Article 252 of the Constitution. Now, what is envisaged in the 1972 legislation is for setting up of national parks and sanctuaries to protect wildlife and propagation of wildlife. It also later on started regulating and at times prohibiting national and international trade in wildlife. But much was desired, and therefore, amendments were brought into the legislation in 1993, 2002 and 2006. In 2013, a bill is prepared which has been introduced in the Rajya Sabha. It is called Wildlife Protection Amendment Bill of 2013, wherein there was the suggestion to include a separate chapter on India's international obligations. There is a convention on international trade in endangered species of flora and fauna. Now, this convention is the one to which India is a party, and therefore, there was the suggestion made by the committee set up for that purpose to include the CITES obligations. That CITES stands for the Convention on International Trade in Endangered Species, adopted in 1973. The CITES obligations are now appearing in the bill of 2013 in the form of chapter 5B. In the meanwhile, the Ministry of Environment also has come up with a manual on wildlife to help the enforcement personnel to stringently implement the Wildlife Protection Act provisions. This was in the year 2007. Now, the purpose is to see that one of the major deficiencies of which has come across at the time of implementation was that the enforcement personnel were not at times familiar with the way the act could be used. So, in order to identify the species or the animals, birds, etc., particularly the species varieties, the manual gives even the photographs, so that the enforcement personnel could take necessary action accordingly when there is activities of illegal wildlife trade. Now, moving to the Water Act. The Water Act was enacted in the 70s to prevent and control pollution caused to the water bodies. Now, one can see a definition of pollution provided in the Act itself, which suggests quite a detailed definition in terms of contamination of water or the presence of certain substances whereby that would be harmful or injurious to the health of the human beings or to animals, carrying out of certain domestic, commercial, industrial or agricultural activities, which could also be threatening the life and health of animals or plants or of aquatic organisms. So, there is a detailed definition being provided in the Act itself. Now, under the Act also, in order to control pollution, the central pollution control boards and the state pollution control boards been envisaged, and they have been constituted, which are having been vested with certain functions and powers, which would also go to the extent of inspecting the polluting units at times and sending the reports, sending the samples to the labs, and at times to take necessary action in order to control pollution. Now, pollution of water bodies like streams are considered as offences under the criminal law, and accordingly penalty is been suggested. There is a separate portion dealing with offences by companies and government departments. So, one can see that the Water Act also will take the criminal law route to see the regulation of pollution. So, accordingly the penalties and offences are characterized. Now, the next one is the Air Act, which also emphasizes on control of pollution, but here the emphasis is on prevention and control of air pollution. And therefore, it defines an air pollutant, what amounts to an air pollutant, and the definition says any solid, liquid or gaseous substance including noise present in the atmosphere in such concentrations as may be or tend to be injurious to human beings or other living creatures or plants or property or environment. One can see that it involves all substances which could contribute to air pollution, including noise. So, what amounts to a noise pollution, there are separate rules which are provided under the Act. Now, again there is a pollution control boards which have been vested with the powers, and at times the pollution control boards could actually apply to the court to restrain certain activities. And the state government has the power to declare air pollution control areas, and there are examples like in the case of West Bengal, the whole of West Bengal has been declared as an air pollution control area. Like the Water Act, the Air Act also deals with offences by companies and government departments, and to that extent criminal law of the country is being used. Now, there is an umbrella legislation which has been brought into effect in 1986. This was in the aftermath of the Bhopal gas leak disaster. Now, this is a legislation which is covering environment in general for the whole of India, and accordingly they define environment as including water, air, land and the interrelationship which exists among and between water, air and land and human beings, other living creatures, plants, microorganisms and property. So, a holistic definition of meaning of environment is provided under the Environment Protection Act, and this act also brings in a number of rules, regulations and notifications in the form of delegated legislation. So, we can see the Environment Protection Rules of 1986, the Hazardous Waste Management and Handling Rules of 1989, notifications like the Environment Impact Assessment, the EIA is one which is required specifically for any development projects. Now, what amounts to having given a meaning of environment, it also defines on environment pollutant, what is polluting the environment as any solid, liquid or gaseous substance present in such concentrations as may be or tend to be injurious to environment. It also gives a meaning to hazardous substance, that is any substance or preparation which by reason of its chemical or chemical properties or handling is liable to cause harm to human beings, other living creatures, plants, microorganisms, property or the environment. Now, the powers of regulating the environment for that matter is vested with the central government, and a complaint could be brought in by the central government or any authority or person authorized in that behalf, and in exceptional situations even individuals could bring in complaint. Now, this act also deals with, like the Air Act and Water Act, offences by companies and government departments are dealt with separately. Now, in the year 1991, a Public Liability Insurance Act was brought in. Again, these all are acts after Bhopal gas leak, and which was envisaged to give immediate relief to victims of an accident arising from handling hazardous substances. Now, here the liability is fixed on the owner based on no fault basis. So, there is no requirement of fault in order to fix the liability. Now, it imposes a duty on the owner to contribute to the relief fund to take up insurance policies accordingly. Now, what is termed as an accident, in order to invite liability of the owner on no fault basis, is that which involves a fortuitous, sudden or unintentional occurrence while handling any hazardous substance, resulting in a continuous, intermittent or repeated exposure to death of or injury to any person or damage to any property. However, the accidents involving hazardous substances occurring due to a war or radioactivity are excluded from the scope of Public Liability Insurance Act. Now, there is also the roles being envisaged for the state government and state pollution control boards. Again, under this act, offences by companies and government departments are dealt with separately. So, a perusal of the acts like Air Act, Water Act and Environment Protection Act along with the Public Liability Insurance Act shows that the criminal law mechanism is being used in order to tackle the violations. Now, in 2002, India has enacted the Biological Diversity Act. This was in order to comply with the obligations of India under the Convention on Biological Diversity concluded by the UN in the year 1992. Now, India is a country with a rich reservoir of biological resources, and access to these biological resources for research purposes and for commercial utilization is a long pending demand which involves foreign partners or institutions. So, what the Biological Diversity Act looks at is regulating the biological resources access by categorizing the people who are using it in accordance with the involvement of, by looking at the element of foreign participation. So, the first category under this legislation needs a prior approval of the National Biodiversity Authority if the use of these resources are for research, commercial utilization or biosurvey and bioutilization. In category 2, it needs an approval. It shall give, it is not an approval, it needs a prior intimation to be given to the state biodiversity boards, and this is for those categories of people like the citizens of India, any body, corporate or undertaking or organization registered in India, thereby showing that it is not having a foreign involvement in it. Now, there are exemptions from this approval or regulatory process provided to people or local communities of the area, the growers and cultivators of biodiversity and the practitioners of indigenous medicine. The National Biodiversity Authority is constituted under the Act, which emphasizes on regulating research, commercial utilization, etc., involving the biological resources of India. They also have the role of advisory role to be performed vis-a-vis the state governments and central governments, and take measures even to oppose the grant of IPR in any country outside India on any biological resource obtained from India or knowledge associated with that resource. Now, the Act also has provisions for constitution of state biodiversity boards, which advises the state governments on conservation and sustainable use of biological resources. There are also provisions for equal benefit sharing. If the resources and the knowledge related thereto are accessed by the researchers or the commercial users, there needs to have a mechanism of benefit sharing. Now, the Act provides for various kinds of benefit sharing, like a grant of joint ownership of the intellectual property rights to the National Biodiversity Authority or to the claimers, transfer of technology or the location of production, research and development units to be in such areas which would therefore facilitate better living standards for the claimers. Then association of Indian scientists, benefit claimers and local people in the R&D initiatives, setting up of venture capital fund for supporting the cause of benefit claimers, payment of monetary compensation and non-monetary benefit. So, there are a number of mechanisms being provided, envisaged under the Act for giving an equitable sharing of benefit to the claimants of the knowledge or those protectors of the resources. Now, in the case of monetary compensation, the money needs to be deposited with the National Biodiversity Fund. So, there is the constitution of a National Biodiversity Fund being provided in the Act. Now, in 2010, we have enacted a National Green Tribunal Act, wherein it facilitates a complaint by any person on an environment dispute or a person who wants to have compensation. So, there is a dispute settlement body which has been created exclusively relating to matters on environment and the compensation claims. Now, it has its principal office in Delhi with other places of sitting in Bhopal, Pune, Kolkata and Chennai. Now, the National Green Tribunal Act provides for the application of principles of natural justice in order to determine the cases. There is a time limit within which the disputes or claims should come before the tribunal, and the tribunal consists of judicial and judicial members and also experts in the working in the field of environment. Now, the tribunal decisions are subject to appeal to the Supreme Court.